to supply to the court as well as to the parties a decision by the Court of Appeals with Kisii in revision number 154 of 2019 by Justice A.K. Ndungu, where Your Honor, there on paragraph 3, the DPP appealed because the court refused to give consent in a case where we were seeking to withdraw the matter to allow room for further investigation due to new information. Your Honor, the appeal was successful. Your Honor, we invite the court to look at the case laws on paragraph 30 and 31, 34 and 35 that the learned judge relied on. To just highlight is that the court must the parameters that the court must look at to ensure that this application is made in good faith. If Your Honor, it affects the public interest, administration of justice, and avoids abuse of the legal process. Your Honor, indeed, Your Honor, we are trying to avoid abuse of the legal process in the event, Your Honor, that the review may affect the trajectory of the matter. Your Honor, the application is made in good faith. And it's our prayer, Your Honor, that the DPP is allowed to withdraw the matter so that we ensure justice is done. Now that would be all.
Constitutional mandate in terms of prosecution of offenders. Your Honor, just briefly, the complaint hearing was registered on 3rd of May 2024 at the DCI Parklands police station, and the investigations commenced. And very comprehensive statements were taken. These are in the court file. And on 8th of August, the file was forwarded to the DPP for approval of the prosecution. Because it was taking a lot of time, we wrote a complaint letter to the ODPP on the 19th of August, like to supply it to the court, complaining as to why the approval was taking too long. And the ODPP replied to that letter.
My senior continues.
Yeah, I didn't supply you.
You are not supplied. I've not been supplied at all, so I have not paid to anything.
No, that was communication between us and the ODPP.
And that's my problem. The challenge is,
Yes.
counsel is presenting evidence from the bar, which we do not have an opportunity to address.
I'm just giving the court the background so that to show how malicious this application is, because this is not a new matter.
Yeah,
It's an application from the DPP.
Yes.
It's not from your end. So I'm sure the DPP will respond to this content.
Yeah.
Yes,
Yeah.
yes. So that letter was responded to, and the DPP confirmed that the file had been approved for prosecution and forwarded to the DCI Parklands through the DCI headquarters. I have a copy of that letter. And he directed that his file be withheld because the Parklands file was ready. The BFID he called the DCI partners and say they can proceed with prosecution, and if the investigation should bring in further investigation, then the two files, that new evidence will just be brought in to build up the case. So we do not understand why it is being said there are two files on the same investigations, yet the complainants are the same people. We are the same people who went to the BFID in December 2023. And because the BFID was taking too long, we also complained to Parliament's DCI. So it is the same department, it is the same investigations, and the facts are the same. There is no new information. The file from BFID can be brought in and consolidated as we proceed, because there's a lot of money at stake here. If you look at the charge sheet, it talks about 112 million, but we think that is just the tip of the iceberg. What has been lost is a lot. In terms of, I'm not moving too fast. In terms of the exercise of the constitutional mandate of the DPP, there is a plethora of authorities that allude to the fact that the DPP should exercise its mandate judiciously and not capriciously.